Welcome to Basics to Representing Yourself in Court, presented by 144,000teachers.org, references from www.irepmyself.com, edited by Odette Boily, June 2018. This self-represented guideline is for any common law jurisdictions, North America, the UK, and elsewhere. Representing yourself in court. Luke chapter 12, verses 11 and 12. And when they bring you unto the synagogues and unto magistrates and powers, take ye no thought how or what thing ye shall answer, or what ye shall say, for the Holy Ghost shall teach you in the same hour what ye ought to say. John chapter 14, verse 26, But the Comforter, which is the Holy Ghost, whom the Father will send in my name, he shall teach you all things, and bring all things to your remembrance, whatsoever I have said unto you. Acts chapter 4, verses 18 to 21, And they called them, and commanded them not to speak at all, nor teach in the name of Jesus. But Peter and John answered and said unto them, Whether it be right in the sight of God to hearken unto you more than unto God, judge ye, for we cannot but speak the things which we have seen and heard. So when they had further threatened them, they let them go, finding nothing how they might punish them because of the people. For all men glorified God for that which was done. Representing yourself in court, preparation and trial. Before you start filing court forms and going to court, you need to figure out what your case is about. To do this, you will need to learn a few basic legal skills. You need to know about the court systems, provincial, federal, international. You need to know about your rights and their restrictions. You need to know how to conduct legal research and how to organize your evidences. You need to understand parts of the law and how the law applies to the facts of your case. You need also to learn dress code and court procedure. Trial. Here is what to expect when going to court. You will not be able to make an application one day and get an order the next day. Expect to come to court multiple times. The more complex and adversarial your case is, the more time you will spend in court. The judicial system in Canada. How the courts are organized. The federal and provincial and territorial governments are all responsible for the judicial system in Canada. Only the federal government can appoint and pay judges of the superior or upper level courts in the provinces. Parliament can also establish a General Court of Appeal and other courts. It has created the Supreme Court of Canada, the Federal Court, and the Federal Court of Appeal, as well as the Tax Court. Criminal cases. Parliament also has exclusive authority over the procedure in courts that try criminal cases. Federal authority for criminal law and procedure ensures fair and consistent treatment of criminal behavior across the country. Provincial jurisdictions. The provinces administer justice in their jurisdictions. This includes organizing and maintaining the civil and criminal provincial courts and civil procedure in those courts as human rights. The link presented here is to give you further information regarding the judicial system in Canada. The Canadian Department of Justice. Judicial structure, an outline of the court system. The first level is the Supreme Court of Canada, which is subdivided in three levels: the Court Martial, the Appeal Court, which has to do with the military courts. The provincial territorial courts of appeal, which have to do with the provincial territorial superior courts and the provincial territorial courts, as well as the provincial territorial administrative tribunals. The third section is the Federal Court of Appeal, which also includes the Tax Court of Canada. The second level will be the Federal Court and the Federal Administrative Tribunals. The Supreme Court of Canada. The Supreme Court of Canada, the final court of appeal. The Supreme Court of Canada is Canada's final court of appeal. Its 9 judges represent the 4 major regions of the country. 3 of them must be from Quebec to adequately represent the civil law system. The Supreme Court, 2 main functions. It hears appeals from decisions of the appeal courts in all the provinces and territories, as well as from the Federal Court of Appeal. The Supreme Court judgments are final. It decides important questions about the Constitution and controversial or complicated areas of private and public law. The government can also ask the Supreme Court for its opinion on important legal questions. The Federal Court, the Tax Court, and the Federal Court of Appeal. The Federal Court specializes in areas such as intellectual property, maritime law, federal provincial disputes, and civil cases related to terrorism. The Tax Court specializes in hearing appeals from tax assessments. The Federal Court of Appeal reviews the decisions of both these courts. In fact, it is the highest court of the land for about 95% of all cases. We refer you here again to the link to further study on the justice system of Canada. This is a comprehensive and sample diagram of the Canadian legal system. Judges, court staff, officers, legislation, lawyers, and case law. The judiciary. Judges are responsible for enforcing laws codified in legislation and in case law. The court staff and officers are responsible for putting cases before judges and making sure the cases run as efficiently as possible. The legislation, Parliament, and members of the provincial legislatures create laws that judges are responsible for enforcing. Lawyers are officers of the court, and they assist and represent persons who are defending an action or are instituting an action against someone. Case law are cases that have come before the courts already. If these cases are close enough in fact pattern, brother judges must follow in line with those judgments if certain conditions are met. The Judicial Provincial Court. The Provincial Court. The court is subordinate in relationship to the superior courts. The phrase provincial court or territorial court is often used to mean a low-level court whose decisions can be reviewed by a superior court. Decades ago, they were managed at the local municipal level. The court system. The court system is roughly the same across Canada. Except for Nunavut, each province has 3 levels: provincial and territorial or lower courts, superior courts, and appeal courts. The Nunavut Courts of Justice has a single-level trial court. Family law. Cases deal with matters of custody, access and support, child protection, so long as these are not incidental of or were not previously a part of a divorce application. Cases are heard by a judge only. Appeals from these cases are heard by the Superior Court of Justice. Criminal law. The court deals with approximately 95% of criminal charges laid within the province and has responsibility for other matters pertaining to criminal law including authorizing search warrants, bail hearings, and peace bonds under Section 515 and 810 of the Criminal Code, respectively. We invite you to visit the link presented here for further information. How a judge can rule. Supreme Court of Canada judgments. All judges across Canada must follow in line with these rulings if the fact pattern is similar. Provincial Appellate Court judgments. All judges in that province must follow these judgments if the fact pattern is similar. Superior Court judgments. All Superior Court, Provincial Court judges must follow these judgments if the facts are similar. Provincial Court Administrative Board judgments. All provincial judges, administrative boards must follow in line if the facts are similar. Binding versus persuasive. If a higher court in a province has ruled on an issue and the facts are similar enough, a lower court in the same province must follow in line with that decision, even if legislation says something else. This type of case is called a binding case. All cases from the Supreme Court are binding in all provinces, in all levels of courts' administrative boards. If a case is not binding, a litigant can argue a case is persuasive. United Nations International Courts. United Nations International Court of Justice, or ICJ. The International Court of Justice, in French, la Cour Internationale de Justice, is an international organization. It is the main judicial organ or branch of the United Nations. In short, International Court of Justice is ICJ. Sometimes people call it the World Court. Established in 1945, ICJ has its headquarters at The Hague in the Netherlands. The ICJ began its working from 1946. It replaced an earlier similar court named Permanent Court of International Justice. The International Court of Justice is different from the International Criminal Court as it deals only with states' or countries' matters. The ICJ uses two languages, the English language and the French language. The International Court of Justice has two major functions. Firstly, it settles disputes which the member countries may bring before it. Secondly, it may give its opinions on legal matters. Generally, all the 15 judges of the ICJ sit together to hear and decide any matter. However, sometimes smaller chambers of 3 to 5 judges hear and decide a case. Such chambers may be for special types of cases. Sometimes the ICJ sets up ad hoc chambers to hear and decide particular disputes. While deciding the case, the ICJ applies the principles of international law. It also uses the laws of the civilized world. This may be the civil and criminal law of major countries. It may also refer to legal writings, law books, and earlier decisions while deciding any matter. Please refer to the link attached for further references. United Nations International Courts. United Nations International Criminal Court, ICC, trying individuals for genocide, war crimes, crimes against humanity, and aggression. The International Criminal Court, ICC, is the world's first permanent international criminal court, which is established and governed by the Rome Statute. It is located in The Hague in the Netherlands. The adoption of the Rome Statute in 1998 was an historic step reflecting the determination of the world community to put an end to impunity and to contribute to the prevention of crimes which threaten the peace, security, and well-being of the world. The ICC has jurisdiction over the most serious crimes of concern to the international community: genocide, crimes against humanity, and war crimes committed after the 1st of July 2002. Please make sure to refer to the link attached to look at the Rome Statute. While deciding the case, the ICC applies the principles of international law. It also uses the laws of the civilized world. This may be the civil and criminal law of major countries. It may also refer to legal writings, law books, and earlier decisions while deciding any matter. Please make sure to visit the links attached. United Nations Human Rights Council. The United Nations Human Rights Council, UNHRC, is the United Nations system intergovernmental body responsible for strengthening the promotion and protection of human rights around the world. Its 47 seats are filled by member states elected for 3-year terms. The UNHRC is the successor to the UN Commission on Human Rights, UNCHR, CHR, and is a subsidiary body of the UN General Assembly. The Council works closely with the Office of the High Commissioner for Human Rights, OHCHR, and engages the United Nations Special Procedures. The UNHRC addresses human rights-related situations in all UN member states. The UNHRC also addresses important thematic human rights issues such as freedom of association and assembly, freedom of expression, freedom of belief and religion, women's rights, LGBT rights, and the rights of racial and ethnic minorities. In July 2011, the UN Human Rights Committee adopted a 52-paragraph statement, General Comment 34, on the International Covenant on Civil and Political Rights, ICCPR 1976, concerning freedoms of opinion and expression. Make sure to visit the links for further information. United Nations Human Rights Council. United Nations International Covenant on Civil and Political Rights. The International Covenant on Civil and Political Rights, or ICCPR, paragraph 48 states, prohibitions of displays of lack of respect for a religion or other belief system, including blasphemy laws, are incompatible with the Covenant except in the specific circumstances envisaged in Article 20, Paragraph 2 of the Covenant. Such prohibitions must also comply with the strict requirement of Article 19, Paragraph 3, as well as such articles as 2, 5, 17, 18, and 26. Thus, for instance, it would be impermissible for any such laws to discriminate in favor of or against one or certain religions or belief systems or their adherents over another, or religious believers over non-believers. Nor would it be permissible for such prohibitions to be used to prevent or punish criticism of religious leaders or commentary on religious doctrine and tenets of faith. Article 20, Paragraph 2 of the Covenant states, any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. Please refer to the links presented here for further study. United Nations Human Rights Council. What are human rights according to the UNHRC? Human rights are rights inherent to all human beings, whatever the nationality, place of residence, sex, national or ethnic origin, color, religion, language, or any other statutes. All are equally entitled to their human rights without discrimination. These rights are all interrelated, interdependent, and indivisible. Universal human rights are often expressed and guaranteed by law in the forms of treaties, customary international law, general principles, and other sources of international law. International human rights law lays down obligations of governments to act in certain ways or to refrain from certain acts in order to promote and protect human rights and fundamental freedoms of individuals or groups. Universal and inalienable. The principle of universality of human rights is the cornerstone of international human rights law. This principle, as first emphasized in the Universal Declaration on Human Rights in 1948, has been reiterated in numerous international human rights conventions, declarations, and resolutions. The 1993 Vienna World Conference on Human Rights, for example, noted that it is the duty of states or countries to promote and protect all human rights and fundamental freedoms regardless of their political, economic, and cultural systems. Please make sure to visit the links for more information. United Nations Human Rights Council. Human rights, an expression of universality. All states have ratified at least one, and 80% of states have ratified 4 or more of the core human rights treaties, reflecting consent of states, which creates legal obligations for them and giving concrete expression of universality. Some fundamental human rights norms enjoy universal protection by customary international law across all boundaries and civilizations. Interdependent and indivisible. All human rights are indivisible, whether they are civil and political rights, such as the right to life, equality before the law, and freedom of expression, economic, social, and cultural rights, such as the rights to work, social security, and education, or collective rights, such as the rights to development and self-determination, are indivisible, interrelated, and interdependent. The improvement of one right facilitates advancements of the others. Likewise, the deprivation of one right adversely affects the others. Equal and non-discriminatory. Non-discrimination is a cross-cutting principle in international human rights law. The principle is present in all the major human rights treaties and provides the central theme of some of international human rights conventions, such as the International Convention on the Elimination of All Forms of Racial Discrimination and the Convention on the Elimination of All Forms of Discrimination against Women. Please make sure to visit the 2 links submitted here for further study. United Nations Human Rights Council. Who wrote the United Nations Human Rights? According to Judges, chapter 21, verse 25, every man did that which was right in his own eyes. The principle of non-discrimination is complemented by the principle of equality as stated in Article 1 of the Universal Declaration of Human Rights. All human beings are born free and equal in dignity and rights. We begin with all human beings, which brings in the significant principle of universality, which is closely related to synthesis. Both energies are distinctive of the Aquarian age. One way of capturing the key insights of universality and equality that lie at the heart of the first article is summed up in a concept that Alice Bailey said should be taught to every child, namely the value of the individual and the fact of the one humanity. The United Nations was founded by the occult and has a flat earth map on their official logo. There is a satanic library inside the United Nations building called Lucis Trust. It was founded by Alice Bailey, who was a New Age occultist. The title page of Alice Bailey's book, Initiation, Human and Solar, was originally printed in 1922 and clearly shows the publishing house as Lucifer Publishing, Cologne, 1923. Bailey changed the name to Lucis Trust because Lucifer Publishing revealed the true nature of the New Age movement too clearly. For further information, please visit the links submitted here. Representing yourself in court. Worst case scenario. International Sunday law is enforced. You are charged by the International Criminal Court, the ICC, and the United Nations International Covenant on Civil and Political Rights, the ICCPR, under paragraph 48, which states, prohibitions of displays of lack of respect for religion or other belief system, including blasphemy laws, are incompatible with the covenant, except in the specific circumstances envisaged in Article 20, paragraph 2 of the covenant. Such prohibitions must also comply with the strict requirements of Article 19, paragraph 3, as well as such articles as 2, 5, 17, 18, and 26. Thus, for instance, it would be impermissible for any such laws to discriminate in favor of or against one or certain religions or belief systems, or their adherents over another, or religious believers over non-believers. Nor would it be permissible for such prohibitions to be used to prevent or punish criticism of religious leaders or commentary on religious doctrine and tenets of faith. Article 20, paragraph 2 of the Covenant states, any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. Make sure to visit the links submitted here for further study. Representing yourself in court. Preparation. Before you start filing court forms and going to court, you need to figure out what your case is about. You are charged under International Criminal Court for lack of respect for a religion or another belief system, discrimination, religious hatred, hostility prohibited by international laws. You need to know how to conduct legal research and how to organize your evidences. You need to understand parts of the law and how the law applies to the facts of your case. You need also to learn dress code and court procedure. Make sure to visit the links for further information. Trial. Here is what to expect when going to court. You will not be able to make an application one day and get an order the next day. Expect to come to court multiple times. The more complex and adversarial your case is, the more time you will spend in court. Before going into court, number 1, research, preparation, emotional wellness. A litigant must do a lot of research before stepping foot into court. This includes knowing the rules of that court, knowing how to speak in court, basic procedural formats for making arguments, presenting evidence, knowing which cases are good to support your arguments. Preparation. Preparation may bring confidence. Good preparation may be helpful in so many ways. It is always good to stay on top of making photocopies for all parties, serving documents enough time in advance, and having a well-fashioned set of statements, arguments that supports the party's position. Emotional wellness. Court is stressful. Ask any self-represented litigant and they will tell you the process of representing yourself is extremely stressful. Litigants may get nervous and crack under pressure. This is why most hire lawyers, because lawyers are emotionally removed from their case. Before going into court, number 2, Research, preparation, emotional wellness. Research. What does case law say about the issues in your case? What rules are applicable? Preparation. Do you have these cases printed, highlighted passages? Have I cross-referenced any cases I think are relevant against the rules? Emotional wellness. Preparing far enough in advance gives the litigant time to focus and control their body and mind. Dealing with legal issues continuously may be good reason to seek emotional support from a therapist or counselor, someone removed from the circumstances or immediate family. What forms are we to use in court? The first form is an application or claim. The second one would be to answer and a defense. The third one is an affidavit, and the fourth one is an order. The application or claim, this document starts off any legal matter. It has many names: statement of claim, plaintiff's claim, application, action, information. The second form is an answer or defense. If someone wishes to defend a claim, this document will be appropriate to serve back and file in a timely manner. An affidavit is the written form of a sworn statement. An affidavit has many purposes, primarily giving one version of events under oath. The fourth form, an order. The judge order, this may also include a tribunal's decision, may be written or given orally and must be followed with very limited exceptions. An appeal may stay an order. Note that there are many other forms and each court or tribunal will have their own. They may also have slightly different names. A breakdown now of the forms. Most court forms will have these basic elements. Some may have different names or information sections to fill out. As we go in numerical order, we see that number 1 is the seal, something official from court once the file has begun. Number 2 is the name and address of the court the action has been started at. Number 3 is the file number once the file is created at the courthouse. Number 4 are the names of the parties, the applicant and the respondent. Number 5 are directions given to the defendant, respondent. Number 6 are details of claim being made. Number 7, some forms require facts or pleadings to be stated. And number 8, the date of signing page of applicant or plaintiff, and in the case of criminal form, judge issuing the charge or the police officer that's sworn to charge. We recommend that you may want maybe to increase the view in order to be able to see better the form itself. We will proceed now in giving further explanation on how to fill up these forms, starting with form number 1, application claim. The application claim, this document starts off any legal matter. It has many names: statement of claim, plaintiff's claim, application, action, information. Also for the criminal court. The form number is 4B. The form description is general heading of documents, applications. The form in Word will give you a form that you are unable to edit if you use the one here presented with the link, which brings you directly to the internet, and with also the website where to find it. Note that there are many other forms and each court tribunal will have their own. They may also have slightly different names. Form number 1, application claim. The form number is 4B. The general heading of documents is applications. and the link for the form, the Word form enable editing, and the website are provided here. Form 4B, Courts of Justice Act, General Heading of Documents, Applications, Court File Number, Ontario Superior Court of Justice, between the name of the applicant and the name of the respondent. Application under statutory provision or rule under which the application is made. Title of document, text of document. In a proceeding in an appellate court, follow Form 61B. Form number 1 has been edited April 11, 2012. Form number 2, answer defense. Answer defense. If someone wishes to defend a claim, this document will be appropriate to serve back and file in a timely manner. Form number is 4A. Form description, general heading of documents, actions. The Word form enable editing link is given here along with the website. There are many other forms and each court tribunal will have their own. They may also have slightly different names. Form number 2, answer defense. The form number is 4A. The general heading of documents is actions. The Word form enable editing link is given here along with the website for all the forms that you may need in the future. Form 4A, Courts of Justice Act, with the general heading of documents, actions, the court file number, Ontario Superior Court of Justice, between the name of the plaintiff and the name of the defendant, with the title of document and the text of document. For the title of the proceeding in the case of a counterclaim against a person who is not already a party to the main action, follow Form 27B. B. Third or subsequent party claim in an action, follow Form 29A in all documents in the main action and the third or subsequent party action. C. Garnishment, follow Form 60H. Or D. Mortgaged action in which defendants are added on a reference, follow Form 64N. For the general heading in a proceeding in an appellate court, follow Form 61B. Again, all these forms are available in the link above. Form number 2 was edited November 1st, 2005. Form number 3, affidavit. Affidavit, the written form of a sworn statement. An affidavit has many purposes, primarily giving one version of events under oath. Form number 4D, form description, general heading of document, affidavit. The Word form enable editing link is given here along with the website. There are many other forms and each court, tribunal, will have their own. They may also have slightly different names. Form 3, affidavit. The form number is 4D. The general heading of document, affidavit. The Word form in the link of enable editing with the website are given here. Form 4D, Courts of Justice Act, affidavit, general heading, affidavit of, name, I, full name of the deponent, of the city or town of, in the county or regional municipality of, where the deponent is a party or the lawyer, officer, director, member, or employee of a party, set out the deponent's capacity, make oath and say or affirm. Set out the statements of fact in consecutively numbered paragraphs, with each paragraph being confined as far as possible to a particular statement of fact, sworn or affirmed before me at the city or town of, in the county or regional municipality of, on, and the date, commissioner for taking affidavits, or as may be, signature of the deponent. Form number 3 was edited July 1st, 2007. Form number 4, statement of claim. Where a notice of action 4A is used, the plaintiff shall file a statement of claim 14D within 30 days after the notice of action is issued, and no statement of claim shall be filed thereafter except with the written consent of the defendant or with leave of the court obtained on notice to the defendant. The notice of action 4A shall not be served separately from the statement of claim 14D. The form number is 14D. The form description is the statement of claim. It's an action commenced by notice of action. And the word form with the enable editing is supplied here, as well as the link to the website. Rules of civil procedure, all additional forms are also supplied here. There are many other forms, and each court tribunal will have their own. They may also have slightly different names. Form number 4, statement of claim. The number for the form is 14D with the general heading of documents, statement of claim. It's an action commenced by notice of action. The word form with enable editing is supplied here again with the website to get to that form another way. The Form 14D, Courts of Justice Act, the statement of claim being an action commenced by notice of action, general heading, statement of claim. Notice of action issued on, and you put the date, in an action under the simplified procedure provided in Rule 76, which needs to be added. This action is brought against you under the simplified procedure provided in Rule 76 of the Rules of Civil Procedure. The plaintiff claims. State here the precise relief claimed. Then set out in separate, consecutively numbered paragraphs each allegation of material fact relied on to substantiate the claim. Where the statement of claim is to be served outside Ontario without a court order, set out the facts and the specific provision of Rule 17 relied on in support of such a service, and then sign with the date, the name and address and telephone number of lawyer or plaintiff. The file 14D was edited July 1st, 2007. Form number 5, notice of motion, an appeal. To bring a motion returnable before a judge of the Court of Appeal for an order extending the time for service and or filing of the notice of appeal, a notice of motion 37A must be prepared and a copy of the notice must be served upon the respondents and then filed in the office of the Court of Appeal with proof of service at least 7 days before the hearing date of the motion. The form number is 37A. The form description, general heading of documents, is notice of motion. The word form again is supplied and along with the website. As well, we supply you with the website on how to proceed with a civil appeal. There are many other forms and each court tribunal will have their own. They may also have slightly different names. Form number 5, notice of motion, appeal. The form number is 37A. The general heading of documents is notice of motion, and we supply again the word form. Form 37A, Courts of Justice Act. General heading, notice of motion. Identify here the moving party, will make a motion to the court or judge on the day, the date, and the time, or soon after that time as the motion can be heard, at address of courthouse. The proposed method of hearing, the motion is to be heard, and choose here the appropriate option. Number 1, in writing under sub-rule 37.12.1, because it is, and insert one of, on consent, unopposed or made without notice. Number 2, in writing as an opposed motion under Subrule 37.12.1. The third choice is orally. The motion is for, state here the precise relief sought. The grounds for the motion are, specify the grounds to be argued, including a reference to any statutory provision or rule to be relied on. The following documentary evidence will be used at the hearing of the motion. List the affidavits or other documentary evidence to be relied on. Inscribe here the date, the name, the address, and telephone number of moving party's lawyer or moving party. 2. Name and address of responding party lawyers or responding party. The Form 37A was edited July 1, 2007. Starting a file, responding to a file. Did you start the file? Plaintiff, applicant, police. Paperwork forms need to be prepared. Number 1, a file will be generated by the courthouse. Fees may need to be paid. Number 2, the file will need to be served or given to the other parties, the defendants, respondents, etc. Number 3, once the other parties have opportunity to respond, if they choose to defend the action application, the instituting party may respond to any new information raised by the other parties if they respond. This is typically called a reply. Number 4, once the parties have filed all the initial paperwork, there is a period of discovery where documents are exchanged, served prior to trial. There must also be mediation necessary. Wanting to respond as the defendant respondent, paperwork forms needs to be prepared. Number 1, paperwork needs to be prepared. Number 2, answer, response, defense will need to be served, sent to the originating party, then filed at the courthouse. A fee may need to be paid to respond, filed at the courthouse. Number 3, enter discovery process. Number 4, wait for trial. Temporary relief, bringing a motion. Number 1, motion. A motion or becoming the moving party is a process where a party can get relief or an order from the court before the trial is heard. Evidence. Typically, motions require evidence in writing only. There usually is not oral testimony or witnesses called at motions. Time. There is typically a time limit and certain days of the week the court will hear motions. Arguments, submissions. There is opportunity to speak to the evidence at the motion, in what are referred to as arguments, submissions. Affidavit form. Typically, the evidence heard in a motion hearing is in affidavit form. There may be attachments of documents to the affidavits used at the motion. Temporary relief, bringing a motion. Number 2, affidavit. An affidavit is a sworn document where someone will take an oath or commission the contents of a statement. This statement, affidavit, generally contains only what that person saw or heard, as anything else might be hearsay. Order. Typically, a judge may make an order on the day of the motion. They may also reserve their judgment until a later time. Motions. At motions, parties sometimes seek orders that may include looking for a person to disclose documents before trial, asking to question a witness before trial, seeking an injunction for someone to do something specific before trial, or seek dismissal of the other party's claim or response prior to trial. Before the motion, usually a party cannot speak to or address, make submissions about information that is not filed before the motion in affidavit form. Facts versus arguments. Number 1. Facts proven true. A party can only win a case, what they seek in their original claim, if they present facts that they prove true. Witness. The party has the responsibility of arguing or giving submissions after the facts are proved. Typically, the facts are proved by people giving oral evidence at trial, in the witness box in front of the judge. Rules or acts. If there is any kind of applicable rules or acts, legislation, that applies, these should be argued after the facts are submitted. Evidences. Usually, evidence is given from witnesses at trials, oral testimony, and if believed, the judge may rule with the party which presents those witnesses. Facts versus arguments. Number 2. Examination. The parties both have the opportunity to question each witness at trial. Direct examination versus cross-examination. Judgment. What will be believed by the judge may depend on how the witness holds up to the types of questions asked. Documents. A party simply cannot submit documents to the court and rely on those as evidence at trial. Scrutiny. If a witness created a document, they will need to attest to that document, usually for the judge to believe the document is true. This also subjects the witness and document to scrutiny from the other party when being questioned. Facts versus arguments. Number 3. Sample facts, fictive scenario. Number 1. The defendant was having a Bible study on a certain date. Number 2. The meeting was held in her home. Number 3. One of the participants took offense at what was taught. Number 4. The study was on the biblical versus the state calendar. Number 5. The participant left the meeting very quickly. Number 6. About 20 minutes later, a police officer knocked at the defendant's door. Number 7. Within 15 minutes, all the participants were sent home by numerous armed police officers. Their names were noted for further interrogation. Number 8. The defendant was arrested under the International Criminal Court (ICC) and the United Nations International Covenant on Civil and Political Rights. Number 9. The charges were advocacy of national religious hatred that constitutes incitement to discrimination, hostility, or violence prohibited by the new international Sunday law legislation. The applicant, ICC prosecutor, swore to these facts in affidavit form on the stand in front of the judge at trial. They were disputed by the defendant. Sample arguments, statements, submissions. The biblical calendar is a lunisolar barley harvest as evidenced by the Bible, astronomy, chronology, and history. Number 2. The state calendar is a solar calendar and differs greatly from the biblical calendar as evidenced by history. Number 3. The defendant has investigated these subjects years before the present international Sunday law was enacted, as evidenced by material in her possession, media participation such as 3 websites, Facebook account, over 80 videos on YouTube, and her own publications. Number 4. At such time, her freedom of speech was granted, as well as a religious liberty under the Charter of Rights and Freedoms of Canada 1982, under Fundamental Freedom Article No. 2, and her God-given right as a free citizen. Number 5. Henceforth, the defendant claims the right to a fair trial in order to prove that her teaching does not advocate national religious hatred that constitutes incitement to discrimination, hostility, or violence prohibited by the new international Sunday law legislation. Number 6. The applicant did question and challenge the defendant's claim. He did argue the facts presented by the defendant, but the defendant was allowed a self-represented trial. Once the evidence will be heard at trial, the defendant will be able to argue in a period of the trial referred to as closing submissions that her teaching was biblical, yet will be challenged by many witnesses brought by the applicant on many subjects of the defendant's teaching. A final decision will be taken by the ICC. If found guilty, the defendant could face the death penalty. Hearsay. Hearsay is typically any out-of-court statement used to prove the truth of a fact. Hearsay on its face value is not usually permitted. The best evidence usually has to be given. There are complex rules for when the court will allow or not allow hearsay evidence to be given or admitted as evidence, admissible or inadmissible. Hearsay can be written or spoken. It is usually good to try and remove as much hearsay as possible and present the best evidence to the court. For example, if a nurse wrote a report at the hospital, the report is considered hearsay until the nurse testifies at the trial that she created the report. Hearsay, a testimony consisting of a statement made outside of the courtroom. Hearsay is based on rumors. Rules of evidence. Number 1. The law of evidence, rules of evidence, encompasses the legal principles that govern the proof of facts in a legal case. These will assist the judge to fairly decide on what evidence will or will not be allowed, or what evidence is admissible or not. Ultimately, the rules vary from court to court, family, criminal, etc., although there are a lot of similarities which try to provide all parties with fairness in the trial legal matter. There are two main types of evidence: direct evidence and circumstantial evidence. There are several rules of evidence, most of which is not codified or written in one central location. Instead, these rules are found in case law or common law and sometimes are hard to locate. Rules of evidence. Admissible. Evidence must be able to be used in court. Authentic. Tie the evidence positively to an incident. Complete. Evidence that can cover all perspectives. Reliable. There should be no doubt that proper procedures were used. Believable. Understandable and believable to a jury. Rules of evidence number 2. Generally speaking, important rules, topics that govern admissibility are hearsay, authentication, relevance, privilege, witnesses, opinion evidence, expert testimony, identification, physical evidence, exhibits, objections. Each of these subjects can be expanded on in great detail. When starting to research each subject, make sure you understand a principle before moving on to the next one. Preparing for trial. If you are preparing for a trial, this may take weeks or months. Generally, conferences are held to help parties prepare for trial. At these conferences, the parties may exchange offers to settle the case or specific issues. Offers to settle are sometimes used as a tool to gain an advantage on another party. In preparing for trial, it is good to understand the case thoroughly. You should understand how many witnesses will be called, what evidence will be expected of that witness, and how long to expect that witness to be examined for. Witnesses usually have to be paid a fee for appearing. Each court will have a different rate that needs to be paid for a day of that witness's time. Certain forms or reports will need to be served and filed a certain time in advance of trial. All documents that are intended to be relied on at trial must be served a certain amount of time in advance of trial. Only exception to this is the defendant at a criminal trial. Preparing a witness, number 1. If you are preparing a witness, it is good to first understand what information that person has. A good witness will only speak to what they heard, saw, or experienced firsthand. There are two main types of witnesses: material witnesses and expert witnesses. Expert witnesses sometimes do not rely on what they heard or saw. Instead, they can give their opinions and may influence the judge with their expertise in a certain subject matter. Typically, an expert witness will not be allowed to give evidence about information outside their expertise. It will be good to understand who can be subpoenaed to testify, brought into court against their will, usually material witnesses only. Preparing a witness, number 2. Preparation of a witness typically involves collecting information from a witness and not necessarily trying to influence a witness before trial. If a witness is my witness, they will be subjected to different types of questions from the opposing lawyer party, which may be uncomfortable for them. Witnesses should understand how to deal with this. Any coaching to a witness before trial should be very simple. Here are 3 basic tips for witnesses. Number 1, do not answer the question put to you if you see a party or their lawyer stand up in objection. Number 2, do not answer more than what is asked. Number 3, relax and think about your answer before answering. Note-taking. Note-taking is very, very, very important. Number 1, not only should a litigant be taking notes before the trial, but at the trial as well. Number 2, it is difficult, but notes of questions and answers, and occasionally what time something was asked, answered during the trial from both the self-represented litigant and the other party asking questions, are very, very important. Why? During the trial, you may make an audio recording, but during the trial, you may want to know what was said, and you will not be able to search effectively or efficiently through audio files to find something notable. Taking notes during the trial helps ensure the litigant is present, listening effectively and filtering what is important to emphasize later or play down later in closing submissions. The judge and opposing counsel will be taking notes. It is an impressive thing to show that you are in the moment with them. Offers mediation. An offer to settle can be a tool. Effective mediation happens after all parties have full disclosure, discovery. There can be penalties for not accepting an offer if a party should have. Mediation can go hand in hand with an offer. Usually, a party will expose their cards to the other side during mediation and share their position. Sometimes a party position can be used to settle before trial. If you can avoid going to trial, the time and expense alone, should you? Settling before trial reduces risk and time spent preparing. Figure out what that is worth to you and start there when thinking about what to settle for. Going into a mediation session or putting energy into an offer should reflect that savings of time and risk. If it does not, is it worth it to complete mediation or make an offer? Trial procedure number 1. This procedure can be translated into any type of hearing. Opening statement by originating party, applicant, plaintiff, Crown. Opening statement by responding party, defendant, respondent, optional at this point. Originating party leads their case, calls their first witness. Originating party asks questions to witness number 1, direct examination. Opposing party asks questions of witness number 1, Cross-examination. Originating party gets to ask question of witness number 1, reply, redirect, re-examination. These questions should only come from new information raised by cross-examination questions. Procedure number 3 repeats for each witness originating party calls. Once originating party finishes calling witnesses, their case is essentially finished, with exception. Trial procedure number 2. Responding party may make an opening statement at this time and then call their first witness. Procedure number 3 will apply with appropriate modifications. After responding party is finished calling witnesses, their case is closed. Closing arguments. The originating party will make submissions based on the evidence about why the judge should order with them. The responding party will then make closing arguments. The originating party will get a chance to respond to closing arguments of the responding party only on new information raised. Judge will then make the ruling. Orders. The judge, jury, or trier of fact will first decide on the facts, whether they believe some, all, or none of the facts presented by each party. The judge will then rule on what laws will apply to the judgment and if to order what a party has asked of the court. The judge will then decide on legal cost. The legal system is built as an adversarial system. There will essentially be a winner and loser. The winner will be entitled to some or all of their legal costs being paid by the losing party. Any offers to settle will then be accounted for in the judge's ruling on cost. The judge may make their order, decision, ruling in writing, and even reserve their decision for a period of time, or give it orally. Appeals number 1. Almost any time a judge makes a decision on a motion or at trial, whether relatively insignificant or not, a party may appeal a decision. Any error in law by a judge may be grounds for an appeal. Whether the error is significant enough to change the original judge's ruling is another question. Errors of fact are harder to appeal on because the original judge is in a better position to gauge the facts of the case and credibility of the witnesses. The transcripts of the original hearing will most certainly be necessary for an appeal. Appeal judges will review transcripts to decide on whether the original judge made an error. Appeal judges will review transcripts to decide on whether an appeal will be successful. For most self-represented litigants, the expense of transcripts, sometimes more than $4 per page, may prohibit an appeal from going forward. Appeals number 2. There are typically 3 possible outcomes for an appeal. Number 1, dismissal of the appeal. Number 2, substitute an order that should have been made. Number 3, order a new trial. Appeals are very costly and deal with very stringent timelines and procedural requirements. For this reason, appeals should be avoided at all costs unless absolutely necessary. Legal test, case law. In any legal situation, there may be a legal test already set out in case law. Legal tests are usually created by appeal courts. At all material times, a litigant should be asking themselves if there is a legal test for this particular situation. Even better, a litigant should be able to foresee issues that may arise during the trial and print out and have present in court the applicable legal test case law that supports the litigant's position on any particular issue. For this reason, research and preparation are one of the best tools a litigant can have in their toolbox. This self-represented guideline is for any common law jurisdiction, whether in North America, UK, and elsewhere. Representing yourself in court. Acts chapter 4, verse 19. Whether it be right in the sight of God to hearken unto you more than unto God, judge ye, for we cannot but speak the things which we have seen and heard.